Hello and welcome to Computology Academy. So today we are going to discuss the mains answer writing practice series second question, which was given in the morning time on our Telegram channel. For the question, you can join our Telegram channel and that link has been provided in the description below, so that in the daytime you can practice the question and later on you would come to the discussion, so that you would understand what is the necessity of the question and how to attempt the questions. So here today's question is faster system that has recently been introduced by the Supreme Court. So first part of the question is, what is faster system? So recently faster system has been introduced by the court. So one part of the question will be this. However, the weightage of this part will not be that much. It would contain only 30% weightage. And the rest part would be of more weightage, that is discuss the anticipated benefits. So you should first try to understand how to decipher the weightage of any question. If the question have 2 or 3 different parts, so it becomes very crucial to understand on which part you have to focus more and on which part you have to write more, you have to deliberate more, you have to discuss more, so that you get a good marks. Because if there are various parts in the question, then they are not equally distributed in terms of weightage, and that is why it becomes crucial to understand which parts should be having more weightage. So this anticipation, this technique should be in your mind. So here 70 part of the answer should focus on the anticipated benefits of the faster system. However, we would write an introductory type of part on the faster system, just what it is, how it would work and all those kind of things. So here in the introduction, we would discuss about the faster system, that on the order of a special bench led by the Chief Justice of India, N.V. Ramanna, this faster system had been introduced, and on 16th of July, the preparatory work had started to introduce this faster system. The development of this secure channel and all those back-end technicalities were started, and thereafter the court introduced this faster system. The faster system's full form is fast and secure transmission of electronic records. Faster system. And here the bench approved its use on 23rd of September 2021. So this is a latest event and it might be in the mains question paper, whether it is UPSC or it is state PCS, because this is a important topic related to judiciary. This is a land shift change in the overall functioning system of the judiciary, and that is why this topic becomes very important with respect to the civil services mains examination. And here it is the introduction, and thereafter we would come to the next part, that is body part. And here we would discuss about the benefits, what kind of benefits the faster system would provide in the functioning of judiciary and how it would help out the people who are overall affected by the whole system of judiciary. So first of all, the crucial decisions including the orders on bails, stay on the arrest, can be communicated electronically to the prison authorities as well as the investigating agencies through a secure channel. So here what happens, many a times a person gets bail, as the judiciary itself has taken this so moto initiative after a report was published in the Hindu newspaper that 13 under trials who were pronounced juvenile by the session court 2 decades ago, 20 years ago, were still in Agra jail. However, there is a provision in the juvenile system that a juvenile cannot be under the arrest or in the corrective centers more than 3.5 years, that is 3.5 years. But they have spent 20 years in jail, and it is just because the order was not received or not correctly transferred to the jail authorities, and because of which these juveniles may have been of around the age of 38 to 40 years. If we consider that they might have on the border of juvenile age, that is 18 years, then also they might be around 38 to 40 years of age. So this miscarriage of justice should not be there again, and that is why this suo moto initiative was taken by the Supreme Court, and to introduce this system, faster system, so that if a bail is granted to any person, if stay on the arrest is granted to any person, and the police or the investigative agencies are on the way to arrest that person, or they are in the judicial custody, or they are in the police custody, and if they get the bail, then those authorities should be informed instantaneously through this faster system, through the transfer of electronic records of that order, so that the person who is arrested or who has got the bail should not be suffering at all. And this system will uphold the fundamental rights. And which kind of fundamental rights? Right to life, Article 21, dignity and personal liberty, all these rights, because a person, if he is under trial and if he gets the bail, still he is in prison, then all these fundamental rights are violated of that person. And because of this, to uphold the fundamental rights of such people, the Supreme Court has introduced this system. And it will also ensure that the under trials are not kept behind the bar unnecessarily. Like this was the situation here, the under trials were at that very time were a juvenile, but when they were pronounced juvenile and when there was an order to release them, that order was not received by the jail authorities, and because of that, those people were kept under the arrest, were kept behind the bar, and this was a negligence by the system. This was a miscarriage of justice, and to avoid such kind of things, there should be a proper system, and that system has been introduced recently by the Supreme Court to avoid such kind of misleads or the miscarriage of justice. वैसे भी सुप्रीम कोर्ट कहती है ना कि 100 गुनहगारों को हम छोड़ सकते हैं, लेकिन एक बेगुनाह को हम सजा नहीं दे सकते। तो यहाँ पर उसी चीज को आगे बढ़ाते हुए ये सिस्टम चालू किया गया है कि एटलीस्ट जो पर्सन गुनहगार नहीं है, दैट पर्सन शुड नॉट बी सफरिंग एट ऑल। तो यहाँ पे ये सिस्टम इसलिए इंट्रोड्यूस किया गया है। एंड द नेक्स्ट इज, it would also prevent the unnecessary arrest and custody of a person even after the court had already granted them protection. Many a times it happens that a person has got the anticipatory bail and still the police goes on and arrest them because bail तो मिल गया है, but still the copy of that order is not with that person or the police investigative teams. And because of which, even if a person is having the anticipatory bail, then also he gets arrested. So such kind of things will not be there after the introduction of this system, because the concerned police station or the concerned investigative authorities or the concerned session court, high court, whatever it is, that authority will be receiving this order instantaneously through the faster system, and because of this, the person who has got already bail will not be unnecessary suffering. And it may even communicate the stay on the execution. वो हमारा केस था ना, कौन सा केस, टाइगर मेनन वाला, जिसमें रात के 3 बजे तो सुप्रीम कोर्ट के को खुलवाना पड़ गया था कि इस पे अभी भी स्टे लगाया जा सकता है। इफ इन दैट सिचुएशन किसी भी हालत में अगर टाइगर मेनन को वहां पर स्टे मिल जाता एग्जीक्यूशन पे, और वहां पर तब तक अगर पुणे जेल में उसे लटका दिया जाता बिफोर द ऑर्डर वुड हैव बीन रिसीव्ड बाय द जेल ऑथोरिटीज, तो क्या फायदा होता ऑर्डर का? तो वो हुआ नहीं, अलग बात है। बट यहाँ पे इन दिस केस सिचुएशन, इफ सच काइंड ऑफ कंडीशन अराइजेस दैट द टाइम ऑफ एग्जीक्यूशन इज टू क्लोज, and in that situation if the somehow the Supreme Court grants and stay on the execution of that particular convicted person, then in any case that person should not be executed, and that this situation will ensure, this system will ensure that this situation should not be there. ऐसा नहीं है कि ऑर्डर आ गया सुप्रीम कोर्ट से कि दैट दिस पर्सन शुड नॉट बी एग्जीक्यूटेड, बिकॉज स्टिल वी आर रिव्यूइंग द केस, वी विल रीथिंक ऑन दिस केस, बट वहां पे दैट पर्सन हैज गॉट एग्जीक्यूटेड। तो ये सिचुएशन भी यहाँ पर अराइज ना हो, दिस सिस्टम विल इंश्योर सच काइंड ऑफ थिंग्स। एंड नाउ कम टू द कंक्लूजन। सो व्हाट वुड बी द कंक्लूजन? This will prove a great initiative, definitely great initiative. इलाहाबाद का भी एक केस हमने देखा था जिसमें कि एक महिला थी, and that lady was behind the bars since 13 years after she was granted the bail. उन्हें बेल मिल गई थी, उन्हें एक्विट कर दिया गया था अपने क्राइम से, and she was behind the bars for a petty crime. एक उनपे केस लगा था सिर्फ थेफ्ट का, चोरी का, और उस केस में उन्हें क्या हुआ कि अरेस्ट कर दिया गया। उसके बाद वो जुडिशियल कस्टडी में पहुंच गई जेल। लेटर ऑन शी वाज नॉट कन्विक्टेड, शी वाज एक्यूटेड फ्रॉम दैट चार्ज, बट दैट ऑर्डर वाज नॉट रिसीव्ड बाय इलाहाबाद और नैनी जेल ऑथोरिटीज, एंड बिकॉज ऑफ दैट that lady had to be behind bars for 13 years, and at the time she was arrested she was pregnant, and she gave birth to her child in the jail itself, and when his child was around 12 years old, then he started to try to get out her mother out of jail, and after his attempts, his several attempts, somehow he reached out to the session court, and जब वहां पर उसने रिकॉर्ड्स खुलवाई किसी तरह से, then he came to know कि इनको तो 13 साल पहले ही अगर छोड़ दिया गया होता, बेल की ऑर्डर पहुंच गई होती, तो then that child would have also not been born in the jail, और 6 साल उसे भी बिना कसूर के जेल में रहना नहीं पड़ता, that newborn baby. So this was the situation, and this initiative will prove a great initiative, a boon for the under trials acquitted peoples and the peoples on death row, and it will prevent the miscarriage of justice. Miscarriage of justice, why we are saying that? There are various instances. If we talk about India itself, then 2/3 of the prisoners are under trial, and in that situation what happens, many a times many of the under trials get bail, but the order is not there with the prison authorities, and because of that they still have to be in the jail. फाइलों में कहीं दबकर उनकी एक ऑर्डर रह गई, because all of us know the system, all of us know how it works, कि जब तक कोई एक पर्सन, उसका कोई रिलेटिव अंडर ट्रायल का उसके पीछे न पड़े, उस केस के पीछे न पड़े, तो अपने आप में उनको वहां से निकलना, वहां पे जस्टिस मिलना बहुत ही मुश्किल हो जाता है। एंड दिस इज द सिचुएशन, बट फास्टर सिस्टम मे इम्प्रूव the situation of under trials, and it will reduce the miscarriage of justice, and hopefully if it does so, then it will be a great boon for the under trials who are being kept behind the bars unnecessarily, and it will prevent the undue suffering of the under trials. It will uphold their fundamental rights, it will uphold their right to life, right to dignity, all those kind of things. So this would be the track of the answer. बीच बीच में थोड़ी ज़्यादा डिस्कशन भी होगी, and that is because you should understand the subject matter. The monotony should not be there. However, Do follow us on our social media channels for the questions. Questions are being uploaded on the Instagram, Facebook, Telegram, all these channels. These are the links, and the link for the Instagram is provided in the description below also. Do visit our website for various courses, and do subscribe our channel and press the bell icon to get notified whenever we upload new videos. Thank you very much and have a nice day.